Yes, ma'am. I would like to get on the record that I would like to fire my lawyer on
You
standby.
don't have a lawyer. Remember, we've already been through this. You represent yourself.
Right, but the one that's on standby, I would like him replaced with another lawyer.
Ah, it's him again, the so-called Native American Moroccan royal tribal leader, Esquire. Welcome back, everyone. In today's video, we're diving into 3 court hearings featuring the same Moorish sovereign citizen from Washington that I covered in a few earlier videos. This time, he's making some truly outrageous claims, including saying he's a government asset. Before we jump in, I want to give a big thank you to Old Squishy Gardner for sending me these videos. Going forward, anytime a court channel removes a live stream video, I'll pass it to him so he can post it. That way, you can always watch the full video without interruptions directly on his channel. Now, a quick heads up, the order of these videos is a little mixed up. Last Thursday, we covered the third of 4 trials. So today we'll start with the first 2 hearings and then skip ahead to the 4th trial to wrap things up. Let's get started.
Proceeding with the arraignment is your true and correct name, Sylvester Larnell Evans.
Sylvester Larnell Evans Jr.
And what is your date of birth? Earlier we went over your rights to arraignment. Any questions about your rights to arraignment that I wasn't able to answer?
No, I don't have any questions, but I would like to speak with the judge if possible.
And you'll get it in a moment.
What is the city's recommendation regarding release?
The city is requesting bail or bond amount of 500 on each of the 6 cases. Defendant has a significant warrant fight appear history, including 1 active warrant out of Tacoma Municipal Court. City believes the defendant is a high risk of future failures to appear. And also the city is requesting the court find sufficient evidence to set bail or bond on the 2 review matters as well. City believes the defendant is a high risk of not complying with court orders and a risk of disruption of administration of justice.
Any objection, Mr. Iannutti?
No,
Yes, ma'am. I would like to speak. I would like to.
Just a minute. I'm going to talk to your attorney for a second. And then if you want to say something and it's okay with your attorney, I'll hear it then.
Mr. Evans indicated that he did want to say stuff, and I told him he couldn't. He also asked me to represent information to the court. He is asking the court to release him on his personal recognizance. He wants to assure the court that he would show up in person. He said he was not aware of any of his missed court dates. But I think he also wants to address the court, and I told him not to discuss the facts of the case, and he said he understood that.
Okay. All right, Mr. Evans, what do you want to say?
Yes, ma'am. And I do acknowledge the fact that the previous failure to appears, but if you give me a chance at a personal bond this time, I want to deliver a letter to you hand to hand. I will make the court date because I want to deliver a letter with a message to you hand to hand, which also will be attention to Chief Justice Roberts of the Supreme Court. So I want to assure you that if you give me a chance this time, I assure you I will show up at court, because not only is this connected to the state charges, it's also connected to a federal things that I have going on that I don't want to discuss. But I assure you I will show up. And if you can also, I'm in a tank. I would like to represent myself, and I'm in a tank to where I'm getting mistreated. I'm on 23-hour lockdown. I'm on crutches. I have a leg injury, and it's extremely difficult and mentally strenuous, the things that they're doing to me inside of the jail. That's why I say I want to, if you give me a chance at a personal bond, I assure you I will appear with the letter in my hand for your insight, as well as attention to Chief Justice Roberts, so he can be alerted to what's going on.
Yes, Your Honor, we should consider releasing him. He's promised he'll return, and he's very serious this time, unlike the previous 17 occasions when he was clearly not taking it seriously. We genuinely believe he understands the importance of keeping his word now.
Your Honor, that I will appear. I want to...
Well, sir, with all due respect, you just don't come back. You have 17 prior warrants out of our court. It is your duty to keep your address updated. I think $500 each case is very reasonable. I
can't afford that at the moment. That's why I was asking for personal recognizance. If you give me a chance, I assure you I will be there, because I want to prove that I'm innocent of these charges, and I was at the airport on your orders on personal travel.
I have never ordered anyone to go to the airport.
No, the last set of paperwork you gave me, it said that I can appear, I can go to the airport for personal travel, and that's the only time I've been there. The only time, I assure you.
I'm imposing bail in the amount of $500 each case.
And also, they have me in a tank to where if I'm representing myself, it's going to be extremely difficult. I don't have any access to the kiosk because it's broke. They have me on 23-hour lockdown. I didn't do anything. I haven't been violent or anything with anyone. They just, for some reason, I'm in a segregation tank. I don't know if it's because of my injury or what, but also it's affected my leg because I'm rehabbing my leg. And it's messing with the muscles and nerves because I need to keep my leg active and in motion. And they have me in 23-hour lockdown. I'm not even in general population. So I'm asking humbly and respectfully, could you please grant me one more chance at a PR bond, please?
And Mr. Evans, you have an active warrant right now out of Tacoma Municipal Court.
I'll resolve that as well, because when I went to court, they initially told me it was dismissed. So I guess they just put something back out. I'll resolve that as well. But if I humbly and respectfully ask that you please give me one chance to prove myself, please, because it's almost unbearable for me to represent myself and with my leg injury and the conditions they have me in, and me getting mistreated in the jail as well.
Okay, I've made up my mind. I'm imposing bail in the amount of $500 each case. And I will appoint Mr. Ionati while you're in custody, so that you will have a way. And if you're wanting to do your own research, perhaps you and he can work out a way.
Ma'am, that's the whole point I was trying to make. Mr. Ionati is not properly represent me. That's why I wanted to represent myself. That's how I got back in this situation to where I was reviewed, because before I wanted to do a fast and speedy trial, he never filed the motions. That's why I want to represent myself, and I asked for a PR bond so I can hand you a letter informing you of everything that's going on, as well as a letter that you can forward to Chief Justice Roberts to alert him what's going on. And
I'm not forwarding anything to Chief Justice Roberts.
I understand, but I have evidence that will exonerate me. And I wanted to hand that letter to you in person.
Anything you give to the court, you have to give to the city as well. I can't look at it unless the city has it as well.
I understand, but I wanted to file it and make sure that you're in position soon as I hand it to you or the courts, that they're able to go ahead on and put a seal on it so it's not exposing, because anything I send from any letters I mail out.
You have to make a whole motion to file it under seal. Sir, there's a lot. This is very complicated what you're proposing.
I understand, and I have the evidence that proves that will prove and will exonerate me, but I don't want to send everything through this jail because there's so many eyes that's gonna see it. In addition to that, the circumstances and the conditions they have me in is unfeasible.
JL, this isn't supposed to be fun. And honestly, you could have prevented this whole mess. All of this trouble comes from missing 17 court dates. Showing up on time would have kept you out of this situation entirely.
I'm in 23-hour lockdown. I'm in a cell to where there's no access to the kiosk where I can look at the law library. In addition to that, I'm in a...
Mr. Ionati, when would you like to set this over till?
Thursday.
All right, Mr. Evans, we'll see you back here on Thursday.
Would I be able to request a PR bond at that time, or is everything?
No, you're only entitled to one bail hearing unless there's been a change in circumstances.
What about the jail conditions they have me in? I'm in 23-hour lockdown. I didn't do anything, and I'm not even don't even have access to the law library because the kiosk is busted.
I've appointed Mr. Ionati while you're in custody, and or at the very least a standby counsel. You can talk to him about how you want to deal with that.
Okay, and is it okay if I represent myself?
You'll have to go through there's a form to fill out.
Can Mr. Ionati give me that form, and can this be on record that I'm saying that I want to represent myself and that I need the forms or whatever I need to be, and I would like a fast and speedy trial as well.
Yes.
Well, you've said that the speedy trial in custody is 60 days.
I understand that, but I want it on record because last time I told Mr. Iannetti this, he never made any motions to get the process started. That's why
There is no motion to make to get it started. The clock starts ticking at arraignment.
I understand, but I would like to represent myself if
And that's fine. You can represent yourself. I mean, you can file the petition to represent yourself. I don't know whether I'll accept it.
it's gonna be extremely difficult to do that with the circumstances I'm in.
I can give you the information and go over what you need with you.
I can imagine his lawyer thinking, absolutely. I'll get you the paperwork to remove me from your case. No problem. And just like that, his arraignment wrapped up. Now, we're moving on to his next hearing, which is the pretrial conference. This is where things start to get more interesting, as the court begins to set the stage for the trial itself.
When I spoke with him, because he's in custody right now, I know he wants to address his in custody status with the court, but I figured this needs to be addressed first. We discussed if he's in custody, he needs access to certain things and that unlikely he can get. So he would want an attorney on standby to assist him with that. And I said that I don't have any conflicts, so I don't have any issues doing that if that's the case. But just so the court's aware. But I know he wants to address his conditions of release, but he also wanted to represent himself.
I would like to speak to Your Honor before we disconnect if possible, please.
All right, Mr. Evans, so it's my understanding that you do not want an attorney to assist you. Is that correct?
Like you said, if he could be on standby, I would like to represent myself because I invoked my right as a Aboriginal Native American Indian chief. That's what I asked if you got that letter. So I have certain constitutional rights that's afforded to me. In addition to that, I have a leg injury where I'm on crutches and they have me in 23-hour lockdown. I didn't do anything wrong. And I was trying to see if it's possible, based on the fact that I invoked my right as an Aboriginal Native American Indian chief, that I definitely will appear at every appearance if I could get a pre-recognizance bond due to the circumstances. I assure you I'll show up, especially that I invoke my right as a Native American Indian chief.
And as the prosecutor stated earlier, Mr. Williams, I guess, what is the change? It doesn't sound as if you're noting any change of circumstance from when the court saw you on Monday and set bail.
I sent the proof in the letter that I mailed out.
Wasn't provided to the city. I haven't seen any proof. I would say that's not a change in circumstances.
I mailed the letter out on.
Said?
I mailed the letter out on Tuesday with the evidence and the proof invoking my rights as a Native American Indian chief. So I'll be working to get this case removed to the federal courts. I need to also file in the federal courts a notice to remove as well. And it's going to be extremely difficult for me to do that from here in prison. So that's why I was asking if I could get a PR bond. I assure you I'll show up. I'm not going to play with my rights like that as a Native American Indian chief. In addition to that, I'm in 23-hour lockdown with my crutches and it's affected my leg. I broke my tibia and fibula in 5-6 different places. And the muscles and the nerves in my leg are getting worse because I'm not able to rehab it like I'm supposed to.
Want to hear a fun fact about the tibula? When asked, every single orthopedic surgeon said tibula fractures couldn't be operated on. That might be because the tibula isn't actually a real bone. So, yeah, nice try, bonehead. It's always good to check your facts before making bold claims like that.
Seeing that I wasn't here on Monday, what is the bail currently set at?
500 cash or bond on each of the 6 cases.
And does Mr. Does Mr. Williams have, what is his FTA history?
He does have a substantial warrant fight history, including an active warrant out of Tacoma Municipal Court. Also, has not complied with court orders, and that he repeatedly returns to the airport We have 4 pre-trials and 2 reviews involving those allegations, the same
And
allegation
in
before the
addition to
court
that,
today. Has warrant failure to appear history in pretty much every case.
What is his
that he-
date of birth? I'm trying to find him on Jack's.
my last name is Evans, it's not Williams.
It is 6/7/84.
And also, there's no evidence that I was trespassing each time I was there on valid personal travel. So this case lacks evidence, which is also why I asked to have it dismissed in the letter as well.
He went into that on Monday
And
as well.
And also, I never invoked my right as a Native American Indian chief. This time I did, so therefore I will not miss not one court date, I assure you. Can you please?
I'm not sure what you being a Native American chief has anything to do with you coming to court.
Because I represent a sovereign state, and as a sovereign state, I have the right to have these cases heard before the United States of America.
Well, good news for you. Washington is, in fact, part of the United States of America. No matter what claims are made, it's firmly within U.S. jurisdiction, so all the state and federal laws apply here. There's really no escaping that fact.
Put the details that prove what I'm saying, and also it should prompt everything to be moved to the United States Supreme Court, especially with some of the details that I put in there regarding my circumstances and what I have going on, which I'm sure Chief Justice Roberts can verify once the process or whatever, which I'm trying to go through the process now, but it's going to be very difficult to do this from inside the jail. But as a chief of a sovereign tribe that's federally and internationally recognized, I have the right constitutionally to go to, I have immunity, and I have the right as a sovereign state to have this cases heard before the United States of America. In addition to that, I have different types of immunity that I fall under as well.
All right, Mr. Evans, so I gave you an opportunity to speak just to make sure I understood exactly what was happening in this case since I was not the judge on Monday. I have had an opportunity to review your criminal history, and I do see that you have had warrants in pretty much every case that has been filed against you that I can see in the state of Washington. So right now I'm not hearing any change of circumstance that would give me any change in circumstance that would allow me to change the bail from $500 on each case. So that will remain as previously set on Monday.
And also, would you be able to look at a oral motion to dismiss due to lack of evidence at this hearing?
You would have to do that, Mr. Evans. You are acting on your behalf as an attorney. So that is a motion that would need to come from you and or your attorney.
I actually mailed in a letter. I was trying to see if the courts received that letter because that was in the letter that I mailed.
Okay, we do not have that letter at this time. So we're going to set this matter for another pretrial hearing.
Could you set it for sometime next week when you guys get the letter so you can understand everything I'm saying?
I believe we will have to set it in due course in regards to the court's availability.
Yes, Your Honor.
May I inquire if a copy of that was sent to the city?
I mailed it off to the clerk's office, and also, Your Honor, could you please put on note that I requested that that letter gets sealed due to the protection of innocent life, not only mine, but others that's at stake due to the information I revealed about me being a Native American Indian chief and the evidence that I've revealed in it. That, could you please put on note that I asked that it be sealed immediately?
Cool. Well, good news for you. Washington is, in fact, part of the United States of America. No matter what claims are made, it's firmly within U.S. jurisdiction, so all the state and federal laws apply here. There's really no escaping that fact.
Just want to note for the record that the city is going to object to the motions being heard if we don't receive copies.
Did you hear that, Mr. Evans?
They're gonna... No, ma'am. Could you repeat it, please?
The city has stated since you are acting as your own attorney that if they do not receive the information that you have provided to the court, that they will be objecting. It is a responsibility of you or your attorney to provide any information to the court and to the prosecutor.
All I can do is mail the letter off. I mailed it off. I don't know if the guards kept it or if it gets lost in the mail. I don't know. I can remail the letter, or I can rewrite it and remail it off. But I mailed the letter off. I definitely sent it off, and I have the guard that picked it up. I have documented the guard that picked the letter up. So I definitely mailed it off, and it should be on camera that I handed the letter to the guard.
All right.
He's entitled to an opportunity to respond. We would need it at the very latest by Monday. I mean, if we're setting it for Wednesday.
I mailed the letter off Tuesday. So it may get there today or tomorrow. Because it shouldn't take no more than 1 or 2 days for it to get right there to CTAC court. I mailed it to the 4800 188th Street, and I put on there to the clerk. I attentioned it to the clerk, so that letter shouldn't take that long. If it doesn't come to you guys, that means it got lost in the mail or something like that, and I would have to rewrite it. I do have a rough draft of it. So I will be able to read it out to you verbatim Wednesday if you like, if you haven't received the letter by Wednesday. I did keep a rough draft of the letter, so I could read it out to you verbatim. Or if you don't mind, if you could give me a second, I can go and get the rough draft out of my cell right now and read it to you.
No, we are not ready to address that today. So we will address these matters again on Wednesday, May 29th.
All right. Cool. All right, that wraps up his pretrial conference. If you haven't seen the first video I posted, now's a good time to pause this one and check it out. The link is in the description. Once you've watched it, come right back here.
To fire my lawyer on
You don't have a lawyer. Remember, we've already been through this. You represent yourself.
Right, but the one that's on standby, I would like him replaced with another lawyer.
No, I'm not going to do that. What's the basis for that?
Because irreconcilable differences. The fact that you had to explain to me what an affirmative defense is, when he explained it to me, it was polar opposites. It's nothing that it's irreconcilable differences. It's like, I would rather work with someone else.
So if you do that, sir, speedy trial starts over today. Disqualification of counsel is a triggering event for new commencement.
Okay, so I can't replace him without restarting my speedy trial dates.
Correct.
Which will prolong my time in jail.
I don't know that.
Possibly.
Possibly.
All right, so due to that, it's gonna possibly prolong the time I have in jail. I'll do my best to work with this guy.
No, not even your so-called rights, as the tribal chief of Narnia changed the rules. One of the charges against him, trespassing at the airport, actually falls under both state and federal law. Under USC 49 section 46314, it's a federal crime to knowingly enter restricted areas of an airport without going through proper security. At the same time, Washington state law, under RCW 9A.52.070 and .080, defines criminal trespass. However, just because both jurisdictions apply doesn't mean you can simply ask the court to move the case from state to federal court. That usually only happens in specific situations, like when jurisdictional diversity exists or when the state is clearly precluded from handling the case. Simply claiming it doesn't apply isn't enough.
Mr. Evans, do you want me to represent to the court what we had discussed? I mean, you didn't mention what you just mentioned, but the subpoenas and what you're asking for?
I'm gonna write a letter to her, mail it. I have it mailed out today. I'm gonna write a letter to her as well as the Supreme Court of Washington, the state of Washington, with the things that we discussed, but you can let her know the people that I want subpoenaed.
Sir, so any letter that you send to the court, you must include the city. You have to include the prosecutor, or I can't look at it.
Yes, ma'am.
Okay.
What you mean by I must include the prosecutor?
You have to send it to them as well.
I'm gonna send it to the clerk of court, so they should.
Nope, it's your burden to serve the city.
What's the address for the city?
It's the same building.
It's the same building, so I have to send 2 different letters?
Yes,
I mean, I have to make a copy of it and
Correct.
send. I have no way of making a copy from inside the jail.
you have to make one longhand then.
Oh, well, I don't even have the paper I have is only enough to send 1 letter. They in the jail, they're not even giving me sufficient things to even properly do what you're asking me.
Perhaps you could send it to Mr. Ionati and then he can serve the city and the court.
I would ask that Mr. Ionati, once it's filed, the letter that I'm gonna mail out, once it's filed, he make a copy and send it to the prosecutor.
I cannot look at it unless the city is included.
I understand, but what I said is that once it's filed, that Mr. Ionati gets a copy and send it to the prosecutor, and then you can look at it, which still should be before my next court date.
So that's it. This is the problem with representing yourself, sir, is that you do not understand the rules of criminal procedure. And you can't, you're having ex parte contact if you send something only to the court and not the city.
I'm not in, can you tell the jail, give me sufficient paper so I can make 2 copies? Because they're not giving me the what I need to do what you're asking me.
And that's why I'm suggesting that you send it to Mr. Ionati and then he can make copies for both the court and the city.
Okay, Mr. Ionati, is there a way for you to come? Is there an address that I send this to? I don't have any information on you, Mr. Ionati.
I believe it's on the paper. The orders that you got should have had our address, but we'll get you our address today. And Your Honor, I guess what I spoke with Mr. Evans, and he asked me to let the court know that he intends on subpoenaing Clarence Thomas, and then the United States District Court for the Eastern District of Louisiana, the Honorable Judge Nanette Brown. He's also asking that we subpoena the Apostle Derry G. McCoy Sr.
How about Mr. Onetti serves you a nice, warm glass of quiet down? You've spent this entire time criticizing him, claiming he's not competent to represent you, yet you keep insisting on representing yourself. So no, Mr. Onetti will not be filing anything on your behalf. You'll be handling all of those motions yourself. This is what happens when you choose to go it alone in court.
Witnesses for this case or these cases that need to be brought in. I did, and I told him that I was able to, and he said I could. I just want to make sure, Mr. Evans, I can address the case number that you said.
I don't want to, like I said,
2412.
that's a matter of secret state privilege. I don't want you discussing that.
Okay.
So Mr. Evans, in order to subpoena people in another state, you need to actually go to the Superior Court of those states. Neither Mr. Ionati nor I have subpoena power that goes beyond the borders of the state of Washington.
Would that be grounds to have this case removed to federal courts?
I don't believe so. This is not an issue of federal law. It's not a civil case with amount in controversy over $75,000, nor is it involving parties in other sides of the states, in separate states. There's no diversity jurisdiction. There's no subject matter jurisdiction.
It's definitely, the restitution is gonna exceed $75,000 in the case that I'm found innocent by the jury. In addition to that, it would be biased by the city based on the witnesses will be able to provide testimony that will possibly exonerate me.
Is the city seeking any restitution?
I definitely stated that in the letter, and I asked I made that clearly known to Mr. Ionati if he's doing
Sir, you can't get restitution. I don't know what the basis is for restitution.
If I'm found innocent, I would like restitution for my businesses for each day I sat in jail and they lost potential money.
There is a rule that provides for that is not restitution in the sense that it would go to federal court. This is not a federal, there's nothing in here.
The amount that I'm asking for.
That has nothing to do with it. That's a separate issue. Is the city aware of any issue that would cause this case to be removed to federal court?
No.
And
So
not
this-
even my rights as a tribal chief.
So, your dad passed away in 1993 and supposedly left you in charge of this unnamed and unknown, but federally recognized tribe. You can't give us any details because, apparently, it's a matter of national security. The proof that the tribe exists comes from some obscure 1996 civil case in Louisiana, which is supposedly open to the public, but also sealed, meaning no one can actually see it unless a federal judge decides to allow it. Honestly, there's not enough logic or imagination in the world to make this story add up.
You have asserted that you are a tribal chief. I have seen no evidence of that being true. Just because you say it doesn't make it true.
I gave you the proof, but you needed the physical case in front of you, which has a seal on it. So even if it's in front of you, you still won't be able to see that I'm a tribal chief based on having a case in front of you.
It's
I
my
gave you the-
understanding that Mr. Ionati was able to obtain that document.
Correct, which is a matter of secret state privilege.
So you can't say it's in this document and then not let me see it.
I'm just stating facts. That case is a matter of secret state privilege. So that would be grounds would that be grounds to get it transferred to federal court?
The issue is whether you trespassed at the airport, sir. That's the only issue.
I understand, but as a tribal chief, I have the right to have any grievances between me and the state heard before the United States Supreme Court due to me representing a sovereign state that's federally and internationally recognized, a sovereign tribe that's federally and internationally recognized.
You won't tell me the name of the tribe. You won't show me the document.
It's a matter of secret state privilege, Your Honor.
You can't have it both ways.
I'm just stating facts. It's a matter of secret state privilege.
So no, as I understand it, the city is not willing to transfer this case to federal court.
Mr. Ionetti, I would like to appeal anything that's being declined. I just want to get this on the record that I want it appealed. Anything that's being declined, I want it appealed.
Sir, you represent yourself. It's up to you to appeal.
Okay, no problem. I'll send a letter out today with a notice of appeal to the Supreme Court of the state of Washington.
Appeals from courts of limited jurisdiction, which is what we are, go to Superior Court, not the Supreme Court.
But I'll try to speak to them based on the circumstances that I would like to oblige directly to the state Supreme Court due to the circumstances and the fact that it's connected to a matter of national and homeland security.
The land of make-believe.
You're going to have to show them proof that that's the issue too. You can't just say a thing.
I will show them the proof. I will show them the proof with no problem. It's on them if they want to do their work and research and diligence to get the answers that they want, that they seek.
So,
I
sir,
will
sir,
show them the
sir, once again, courts are not investigative bodies. They will do no research. They will not do an investigation. That is up to you.
I understand it. Exactly. And I'm doing an investigation on my behalf, and I'm providing everything that they're asking me for. They just don't like my answers. I'll deal with that on the federal level when I file a notice to remove once I get out of jail, because I can't do. Also, if Mr. Ionetti, if you can file a notice to remove with the federal courts or with this court, I would like that as well, please.
Do you have any concerns about Mr. Evans' ability to proceed?
I do. I mean, I don't have anything to verify any of the claims that he has made and the information and who he's asking for as far as witnesses in this case lead me to believe that there may be issues.
Do you think it's appropriate to have him evaluated under 1077?
I do.
Does the city have any objection to the ordering of that evaluation?
I have an objection.
Okay.
Can I object?
You can object.
Yes, ma'am. I assure you that I'm 100% competent, and I assure you that everything I'm saying is true. As far as civil case 24012 out of St. James Parish, Louisiana, that is a matter of secret state privilege, and it also verifies the facts that I'm making that you guys claim you cannot prove.
But you won't let us see it.
Mr. Iannetti has to get the case himself.
He has it.
So tell him give it
What?
give it to you.
I
Tell
don't know.
Mr.
Can I identify the case, Mr. Evans?
Civil case 24012 out of St. James Parish, Louisiana.
Can I identify the case and the information that I have?
Like I said, you can give her civil case 24012 out of St. James Parish, Louisiana. If she wants to look over it, it has a seal on that case. So you're going to have to get permission to get that seal removed.
So it's my understanding.
True content.
It's my understanding it does not have a seal.
That's the information that I have is it does not have a seal. It's a 1996 case, Blue Harvest Maritime versus Opal Evans. It was a suit for damages.
That's the guise that it's under, but the true contents of that case is under seal. I assure you.
And Mr.
I guarantee it.
Evans,
I'm not
person
guessing.
who can take it out of seal.
I'm not guessing. I'm guaranteeing it because I became the chief of a federally and internationally recognized tribe when my father passed in 1993, and everything was made official with that case in 96.
Well, here's the problem. You clearly don't know what you're talking about. If a real tribal chief can be prosecuted for committing a crime off their reservation, then it stands to reason that someone claiming to be a tribal chief, but isn't, can absolutely be held accountable for trespassing at an airport.
So if it
Titles
goes to me,
don't
it goes
give
to
you a
the
free
city as
pass
well.
from the
And
law.
are you okay with that?
I would like to have it sealed due to the fact that it's gonna expose innocent life.
It's a matter of
my own.
public, sir, it's a matter of public record. And it's not filed under seal. I don't know what the justification is for sealing it in this court.
That it's gonna affect innocent life, including the names that he named that I don't want named with public, to have public access to those names on that case and whatnot. It's definitely gonna affect innocent life, and it's connected to a matter of national and homeland security.
Mr. Iannetti,
Guaranteed.
what you were able to, what you have in your possession is a matter of public record. Is that right?
The information I just have is what the court clerk told me. She indicated that I can pay $1 a page for the file. They weren't able to tell me how many pages were in the file. They said it was archived based on the age. It is a state court. And they indicated it was a suit for damages, and not consistent.
It's connected to my estates that I have, plural. Is it all making sense now? No.
No.
And there's only, Mr. Evans indicated that there's something in the file that's only one person has the ability to unseal, which
And that's
is not
Chief
consistent
Justice
with-
Roberts.
and that's not consistent with the way the law works. So
I'm
that's
the
where my
rarity.
concern-
I'm the rarity in this case, I assure you.
That's where my concern is. And I mean, the amount of money that could be for the amount of documents in the file, I'd have to ask if the court wants me to try and make that request to get that. I can make that request. I would need funds from the court, and I don't know how much. But a state case that would be doing what Mr. Evans claims is not consistent with my understanding of the law, and the fact that a chief justice is the only one that could unseal something within that case is also not consistent with my understanding of how the law works.
Particularly if it's a state case, I don't see how Chief Justice Roberts would be involved at all. Not to mention, it sounds like this predates him being Chief Justice.
Because it's a matter of secret state privilege, and it's also connected to the United Nations.
Sir, you have two choices, either to stop asserting this or get the document.
If Mr. Iannetti can get the documents, I would appreciate it.
The fact that you just say a thing doesn't mean anything. You have to have the proof.
The only way I can get the documents is for Mr. Iannetti to get it. Otherwise, I can't do it from in jail. If you could give me a PR bond, I would definitely get those documents for you myself.
The problem, sir, is you just keep committing or alleged to have just keep committing new crimes.
allegedly, but I assure you I'm innocent.
So were you able to obtain any documents, Mr. Ainati?
Not without, I'd have to get funding from the court to obtain.
got it.
And they said it was in archive. The person that I spoke to said it was in archive, and they were willing to go down and get it and make copies, but they said it's $1 a page.
Is it all or nothing? I mean, that you have to get the whole file or none of the file?
Because I don't know the answer to that question. I can try and see if there was a judgment out of that case that I can just get the judgment, but I don't know specifically what I'm looking for, because Mr. Evans told me that what I'm looking for is under seal that only Chief Justice Roberts can get me. And I don't think I need to contact Chief Justice Roberts and ask him to give me the document out of that case.
If I'm lying about Chief Justice Roberts, trust me, these state charges, these petty charges are the least of my concern.
I can write a letter to Chief Justice Roberts, but I don't know what that will accomplish.
Can they tell you if anything is sealed?
I asked, and they said there's nothing sealed in that case.
Okay, well, that says something right there.
But Mr. Evans indicated, and is this okay that I say this, Mr. Evans, that what you want is only what Chief Justice Roberts can release?
Correct. It's a matter of secret state privilege, so you're gonna be able to see, but you're not gonna be able to see, so to speak, because the Supreme Court of the United States of America has it set up that way purposely for these type of purposes.
I'm not aware of them having this procedure.
Right, because if you're not familiar with the rights of a sovereign state and a sovereign tribe, you wouldn't know the ins and outs. But it's a matter of life and death that I know this and that I have.
Okay. I am ordering a 1077 evaluation. I have concerns about Mr. Evans' ability to proceed. So this is on the court's initiative.
Is this going to delay my trial?
I'm leaving the trial date set where it is. Ms. Chenwiller, I'm assuming that there's no immunity agreement between you and Mr. Evans.
I would like to put one in place if possible, an immunity agreement based on the right, on the fact.
Sir, so this would be with regard to your conversation with the evaluator. It's not immunity from this case.
Okay, so I have to speak with the evaluator?
To get this
Correct.
done.
Pardon?
City would not object to that to get this done.
Can I make an objection to that?
To what?
The order for the 1077.
Yes, and you have objected. I'm ordering it anyway.
Can I appeal to the Supreme Court or to the appellate courts?
I can't give you legal advice. I mean, I can give you.
Mr. Iannetti, I would like to appeal that decision that the judge made to the Supreme Court of the state of Washington directly due to it being a matter connected to national and homeland security.
I'll come and talk to you about how you file an appeal. Your Honor, and this is, yes, okay, the court checked the right box for this. So the city's indicated that they don't have an objection to an immunity agreement. And so this sounds like Mr.
And I also would like to have a notice to remove this case due to bias and prejudice to the federal courts, please.
That's not a basis to remove a case to the Supreme Court, to the federal court.
Bias and prejudice is not a reason?
No.
And violation of my constitutional rights as well, and civil rights. I think that would be a very valid reason, but I'll let you go with your decision if you failed, if you are.
It's up to you, sir. If you can file to remove it,
Yes,
do you.
Mr. Iannetti, can you please file a notice to remove to the federal courts based on violation of constitutional and civil rights?
No, that won't work. First, he's not your lawyer. And second, just believing that your rights are being violated isn't enough to transfer a case from state court to federal court. There are specific legal requirements for that, and simply claiming unfair treatment doesn't meet them.
Okay.
Unless we're going to be talking about anything legal?
I have no idea, sir. That's between you and the evaluator.
Yeah, if we're talking about anything legal, I want him there as standby counsel to explain my legal rights, far as my legal rights constitutionally and state-wise. But if it's just questions regarding my competency, I can handle that on my own. But once it goes into my rights and whatnot, I definitely need counsel available.
Mr. Arnatti, based on your experience, do they discuss rights other than informing defendants of their rights?
My experience is that they tell them that that they're going to write a report, and anything that they say to them is going to be included in the report. They ask them about their understanding of what the charges are and what their understanding of what the court's role in the case is. I don't believe they ask the person to give up any rights or do anything of that nature, typically.
If they're just asking me if I understand my rights and if I understand the charges, I completely understand that. I could tell you now, I'm being charged with trespassing, and the definition of trespassing, according to the state, is to enter a building without permission, unknowingly or
That's okay. I believe that you know that what the
if the court wants to check the box that he wants us present, then that's fine, and they can notify us, and we'll make an effort to be there or schedule with them when it works out.
No, I don't want them there if it doesn't have it. If the questions aren't pertaining to anything legally, I don't want them there. If it's just questions regarding my sanity.
That actually sounds like a classic pro-SE problem. When you represent yourself in court, you're expected to follow the same rules, standards, and procedures that licensed attorneys do. Keep in mind, real lawyers spend years in law school learning what you're trying to pick up in just a few weeks in the law library. It's a steep hill to climb.
I'm setting a return date for that of June 14th. I'm not striking the trial date at this time. We'll leave it where it is. So we will see you back here for the readiness hearing. Will be your next hearing, sir.
Okay, and the subpoenas, you said you won't be able to honor these
It's not a matter of honoring. I don't have the power. My power and Mr. Ainati's power ends at the borders of the state of Washington.
Okay, would that be grounds for having this case removed to the federal courts, being that I have witnesses that will be able to testify on my behalf that you guys don't have the power to subpoena?
So no, the fact that witnesses are out of state is not grounds to transfer a case to federal court. The parties, it's a matter of diversity of the parties. That's my understanding of federal law. This is something you should discuss with a lawyer, though. I don't do federal practice, so I haven't really thought about this since law school, to be honest, but you can have this conversation with Mr. Ainati.
Also, I would like Mr. Ainati to file a motion to suppress any witness statements or testimony.
You got to do that.
Okay, but I'm putting it on record that I want the witness statements suppressed or any testimony that they're providing, because if they have incentive via the case that I provided you, possibly to provide false testimony.
So a case that no one knows what's in it, and that's going to bias your witnesses?
Based on the fact that they could be under non-disclosure agreements, which is kind of like what's going on with that case.
Okay.
That case is a matter of secret state privilege. So of course you're not going to be able to just look at it and see exactly what's going on with it, other than taking my word and contacting the Chief Justice Roberts, who will send superseding orders, as I stated in the letter.
I suggest that you write to Chief Justice Roberts then for assistance, because I don't know.
Once I go through the appellate process, I assure you I will, and I can assure you he's paying attention to what's going on.
Okay. All right. Well, we will see you back here then for readiness. Thank you, sir. Bail remains as previously set. Do we need a commitment order, Madam Clerk, or can the... Oh, you've got one in here, or I put one in here, I guess. Okay.
They don't mean to add to any difficulty, but the city wants to be sure that it is prepared and clear on its obligations. So the court is leaving the jury trials previously set. So we do have readiness on, was that June 12th we had set up for?
Yeah, it does come 2 days before we'll likely have the evaluation.
Great. So the city will go through its normal witness list and subpoena process, just so the defendant's aware. He had mentioned or named Lance Little, Director of Operations at SeaTech International Port, as a potential defense witness at the last hearing. We're not going to subpoena
And
that
also,
individual. Again, if he's a defense witness, that would be the obligation of the defendant, just to be clear on that.
I would also like to subpoena the Kitsap Airporter CEO that of the airporter that goes to the airport. Kitsap Airporter Charter Bus is the name of the company. Kitsap Airport. I would like to subpoena that guy as well.
Again, just to be clear, that's defendant's responsibility, and he would need to provide that information to the city as well.
Mr. Iannetti, are you taking notes?
I will come to you. You represent yourself, Mr. Evans, so I'll come to you and explain how you can get that done.
My hands are tied inside the jail.
It's kind of funny. You keep saying you want him fired, yet you keep expecting him to do work for you. You can't have it both ways. All right, that's where we'll wrap up today's video. He has another court date coming up on June 12th, and you can bet that either Old Squishy or I will be watching and bringing it straight to you. If you enjoyed this video, hit the like button. If not, hit dislike. But either way, leave a comment below and make sure to subscribe with notifications turned on so you don't miss any of my future content.
I know
I don't even have enough paper.
So, Mr. Evans, I'm going to come talk to you and give you the paperwork so that it can get done. And then once it's prepared, I can file it for you.
And so just to be clear, even though we are leaving the jury trial on because the court entered the order for the competency evaluation, per court rule, the speedy trial is told. Thank you. And the city was ordered to provide discovery to the defendant. What, Mr. Iannetti, do you know the best way to get to that to him in SCORE?
Is there, I think if there is, I mean, is there other stuff other than paper copies? Is there anything else other than documents? I
Potential
can make a
911
copy of
recording.
everything.
There's a potential 911 recording. There's custodial statements I read that's involved as well. I don't have any of that. And I would like a full discovery, everything that the city or state's gonna use in the trial.
And you have a right to that, sir.
I haven't gotten it yet.
Mr. Miller?
I can print everything off that's printable. As far as if there's anything electronic is the only issue. I don't know what, and I can go there and play it for him.
And also, what case is it that we're taking a trial on the 24th? Because I didn't get that information. That information wasn't specified either as well. So
I know, and I said this, sir, at the time, we'll set all of them for the same day. And then based on witness availability and based on what makes sense, we'll just figure out which one goes first that day.
Thank you for clearing that up, Your Honor.
And I'm just repeating myself, sir.
It never was made clear to me when it was officially done. So I thank you for clearing that up for me, as well as officially explaining to me what an affirmative defense was that Mr. Iannetti couldn't legibly or competently explain to me.